Can you discuss the anti-money laundering whistleblower program and its purpose?
The anti-money laundering whistleblower program was implemented to try to combat money laundering, but there's really two components to it. There's the AML, which is the anti-money laundering itself, and the KYC, which is to know your client. The anti-money laundering component incentivizes individuals who know of money laundering itself that is occurring to come forth and blow the whistle. The KYC really affects financial institutions. They have a fiduciary obligation, an obligation to the government, to know their client, know the origin of certain funds, and do some due diligence. And a systemic failure to investigate sources of funds from clients or natures of the certain businesses may result in the financial institutions as well being held liable for money laundering violations, because the government may consider them complicit in the conduct for failure to due diligence.
What things people should be on the lookout for when it comes to money laundering?
Let's just use one big word to start off with: concealing. When you're using United States banks to conceal the origin of funds, when the funds are illicit in nature, then it's money laundering. It's kind of, you know it when you see it. It's a very big umbrella term. Right now, it's very popular to use U.S. banks for all sorts of things, but there's a lot of prohibited countries. For example, Russia is currently being sanctioned. So if there's a Russian oligarch who's concealing the nature of his industry and the origination of the company, and then has a fake or fugazi company named, let's say, Oligarchy 2, and those funds are flowing to Oligarchy 2 to try to conceal that they came from Russia, and thereby getting the benefit of using U.S. banks. That's a violation of the money laundering standards. In the past, money laundering was thought of as cleaning the money, washing the money. So even though when criminals are involved in all sorts of illegal type of conduct, they still need to do banking. So you may also have an interesting intersection nowadays of the AML statutes as it pertains to the emerging legalization of marijuana. Because technically, they're not supposed to be using United States banks, but may. So if somebody has a marijuana company and then calls it MJ Incorporated, rather than, and conceals, says, oh, MJ, that's about Spider-Man's girlfriend, Mary Jane, rather than it's about marijuana, to conceal the origin, because federally it still may not be legal, even though it's legal in certain states. It may have anti-money laundering and money laundering consequences.
Who is eligible to blow the whistle under the AMLA?
Anybody is, but really our firm will give free confidential consultations to anyone who's potentially an AML whistleblower. But really, people are going to need to have specific information. And going back to what I mentioned earlier, there's two tracks. There's individuals who may know of the misconduct that third parties who are using the banks, the money launderers themselves, are having, and they're eligible to be a whistleblower if they know about conduct that results in over $1 million worth of penalty. But let me drop a footnote about that in a second. And then also, there's the people who are inside the banks and the different financial institutions who know these corporate entities have blown their KYC obligations and are either falsifying or ignoring their due diligence requirements. So technically anybody could be a whistleblower if somebody has some intimate knowledge and also has potential exposure, meaning that they're also intimately involved in the laundering of money. That's something that we would go over, because we would consider with the individual what potentially could happen and may happen if the conduct is so pervasive, and there may be certain criminal implications. And that's really why it's important to speak with a money laundering whistleblower attorney before you take certain steps forward. I'll give you just one example. One of the biggest results in history, not necessarily money laundering, but in whistleblower history, was an IRS whistleblower action and SEC to some extent against UBS. And when the whistleblower initially filed the case with the first firm, I'm not saying they did anything wrong, but he wound up in criminal jeopardy before the second firm was involved. So you really want to consult with a firm who focuses their practice on protecting whistleblowers, like our firm, Brown LLC.
Is it possible to receive a whistleblower reward under the AMLA, and what's the amount for that?
Well, if you figure that each year there's hundreds of billions of dollars that are estimated to be laundered, The statute itself provides whistleblower awards up to 30%. 30%. So, I'm the lawyer, I'm not the math person here at the firm, but $100 billion, 30% of that is $30 billion that's eligible, just teed up for a potential whistleblower. And all he or she needs to do is do the right thing and come forward with the information. It's how it's presented to the government. Let me also talk about the AML whistleblower program from a different facet that we didn't talk about earlier. I mean, there's humans that are from the Department of Justice that actually investigate these allegations. I was formerly from the Department of Justice. I had the privilege of serving the country as a special agent and a legal advisor. But these humans who are now in charge of doing these investigations for the particular whistleblower unit, there's not a lot of resources there. They're great, hardworking individuals, but there's thousands of tips and only a few of them. So when you present it to the AML whistleblower unit within the government, you better make it as compact, concise, digestible as possible. So yeah, there's a lot in it. You generally only get one shot at the apple, so you better tee it up as cleanly as possible to maximize your chance to obtain a recovery for you. Also, let me also say, because it's probably important to a lot of people, with the use of an AML whistleblower attorney, you could potentially stay anonymous from start to finish. And you definitely want to consult with your counsel about how that plays out.
And how is hiring an AML whistleblower law firm going to help me?
Well, an AML whistleblower law firm, number one, keep you anonymous potentially from start to finish. Number two, they're going to go over your options with you, whether you should file or you shouldn't file. And number three, when you present this, you need to present it, like I just indicated, as tightly, as digestible as possible, because these are hardworking, overworked individuals. And somebody who represents themselves in court has a fool for a client. That's a well-known adage. Similarly here, if you think you could do it yourself, you generally just can't. You're going to wind up hurting yourself. So a good firm, some of the best whistleblower law firms are those that have experienced the particular type of case that the individual has in the past, and like our firm also has Department of Justice experience, because a lot of the work in the AML realm involves synthesizing information and seamlessly integrating your information with the Department of Justice, and the government is an entity unto itself. So I think it's invaluable, the fact that my experience as a former FBI special agent legal advisor who's taking cases from start to finish that are very complicated, including running and participating in undercover activities. I know what the whistleblower is going through. I know from a personal basis how the process works and how the whistleblower may feel. So a good quality whistleblower law firm like ours could potentially tell you what your options are, hopefully present it in the best possible light, and our firm's only paid if we win, so our firm's going to try to maximize your chance of recovery. Hopefully there's a result at the end. If not, no loss to the client or potential individual, because they're not paid, we're not paid, and we like to get paid.
Before reaching out to a whistleblower law firm, what do you think a whistleblower should do? Should they start gathering the documents before they even have a consultation with a whistleblower law firm?
I would adamantly say no. You really want to understand what you can do and what you can't do before you know it. If you take steps on your own without getting the benefit of somebody else's experience, you're going to be in hot water. It happens time and time again. Sometimes individuals try to report things in their internal compliance hotlines. I always joke around, that's a one-way ticket to getting fired. Most people call us up, go, I called the compliance line, I got fired, and now they're blaming me. So that's definitely not the step you want to take before you speak with counsel. Speak with an attorney first. Number two, if you try to do things on yourself and gather documents on your own, you should only be gathering documents which you have lawful access to. And if you don't, again, you may be in big trouble. So go with a whistleblower law firm. It doesn't have to be our firm. We'd be happy to speak to you and offer you a free confidential consultation, but it's not. Go with a firm that has a focus of their practice in protecting whistleblowers like Brown LLC does.
How can people reach out to Brown LLC?
Well, they can contact us by calling 877-561-0000. We have staff available 24/7 to field the call. We return calls after hours or on weekends when it may be more convenient for the individual. Also, you can visit our website, www.ifightforyourrights.com.